Good morning, everyone. I have great pleasure in welcoming all of you to this Silver Jubilee lecture for Nalsar. It is a proud moment for all of us. And what makes it even more special is that Professor Bakshi has agreed to deliver the lecture. Professor Bakshi has been a friend, a mentor. He has been guiding the university from its initial days. Most of our courses have been organized with this question of, okay, what would it be if we had to present this at any point of time to Professor Bakshi? And so our courses, our readings, our methodology has been hugely influenced by his contribution. He's been very generous with his time. He has mentored, I think it's not nice. No? He has mentored not only students, but he has been kind enough to mentor faculty as well. And all of us have benefited from his advice and from the time that he has given us on like a whole range of subjects. So it's with great pleasure that I welcome Professor Bakshi to this. And I also welcome all of you to this inaugural lecture. The theme that has been chosen is also very, very appropriate. So in a sense, we are marking many things. We're marking that we just finished 75 years of independence, the fact that we're also marking 50 years of Keshananda, and the fact that Professor Bakshi is going to talk about perhaps two very enduring controversies in Indian constitutional law. One is, of course, about the whole idea of how does an unelected branch actually get to decide on what is the basic structure? How is a branch that has not been involved in the drafting of the document or in its amendment actually going to decide on what is basic? And of course, the question tied into it has always been the business of the judiciary appointing itself. So it's wonderful and of course very typical that Professor Bakshi will pick up perhaps two of the most enduring controversies and try to bring them together and promise all of us a very exciting morning. I also invite Professor Krishna Rao to welcome Professor Bakshi.
Professor Upendra Baxi.
Good morning, everyone. I have great pleasure in welcoming all of you to this Silver Jubilee lecture for Nalsar. It is a proud moment for all of us. And
Recording, yeah. Professor Upendra Baxi, Madam Prema Baxi, Professor Amita Danda, my colleagues Vidyulata Vasanti, all friends, and those who have joined both online and in person. It's a momentous occasion for all of us. As all of us, we know we are celebrating 25 years of establishment of Nalsar Law University, which was started in 1998. We started on 5th June 1998. 1st December 1998 was where the academic instruction started in the old campus. So far, we had 3 Silver Jubilee lectures. I have requested Professor Upendra Baxi to deliver this Silver Jubilee lecture on 50 years of Keshavananda Bharati case. Professor Baxi has rephrased it as an enigma of the basic structure and the need for a slow reading of judicial normative labor, the National Judicial Appointment case and beyond. Two things I wanted to share. I don't want to stand between you and Professor Baxi. Firstly, my acquaintance with Professor Upendra Baxi, just Vasanti has mentioned, as a students of LLM, 2 years LLM way back in the Kakatiya University. I think that's the first time I have seriously read law because of 3 years LLB, 81 to 85 in a small Mufassil town in Kakatiya University, full of student politics. Less we have attended, and I was almost all evening law college, but LLM was very serious, and we started 3 compulsory textbooks thanks to My teacher said that time, law poverty, critical access was ready. Supreme Court, and two more books of Professor Baxi, Supreme Court Power and Politics. And after reading that, I went in 1990 to attend for an interview in Jawaharlal Nehru University, MPhil International Legal Studies. MPhil International Legal Studies in JNU is offered to any, not only from law, but also from political science, international relations. MA people also used to come. And after attending, I just called Professor Bakshi. I wanted to meet you. He said, why do you want to meet me? I think he is a vice chancellor at that time in a Delhi university. A vice chancellor giving an interview is very difficult, but he said, come over. That's the first time. And then 1993, my MPhil dissertation in the National Law School, Bangalore. That's again in Hyderabad. Hyderabad, he came for now it's called as a FLU, and earlier was the Center for Foreign CFIL we used to call. So now it's become FLU. So he was my external examiner, and he conducted Viva in FLU at that time, and later his report came. So I know Professor Baxi, my acquaintance with Professor Baxi from 1990, 93, and later on for many years, almost over 3 decades. I know Professor Baxi, unlike other legal academics, he disfavor Vyaktigata puja, means no, we glorify people. Second issue is about Keshavananda Bharati. I was just interacting with Professor Baxi. Keshavananda Bharati case is a power struggle. Power struggle between Supreme Court and Parliament. Political scientists, Rajni Kothari and many people have said, whenever the Parliament is powerful, it will assert its power over the judiciary. Let's go back to the context of 1970s also. 70s, that was a 1973, April 1973, 24th, if I am right, where the Keshavananda Bharati judgment was delivered. 13 judges of the Supreme Court, maybe I may be corrected, maybe the first large bench, 7 versus 6, runs into more than 700 pages. Baxi was the first one to write a commentary on that. He said this is a future constitution in his article in the Supreme Court cases. But Keshavananda Bharati has raised an important issue about the power struggle, pathology's power, how the parliament is trying to assert. And also it is a property. Right to property was the highest recognition of the right to property. Starting from 1950 to 1973, it continues even further. So that's the major parliamentary sovereignty, as Baxi has rightly said. It's again reasserting the parliamentary sovereignty in 1973, but is a limited power. That's a power is not to, other than the basic structure of the Constitution. There's the outlining of the basic structure in 1973. Later on, it was added some more things, whether the judicial power, constitutional judicial power, Professor Baxi calls, whether it is still emerging. That's what the enigma of the basic structure I could understand. And then we should not just limit to NJAC. We should not limit to same-sex marriage, maybe beyond. How this basic structure doctrine should be interpreted, reinterpreted in the coming years. Let's hear from Professor Baxi. Sorry for this basic introduction. Maybe a criminal law teacher trying to understand the Constitution from a different lens. Thank you, and over to Professor Baxi.
this place more disability friendly. All kinds of steps I walked, ladies and gentlemen. I'm very pleased to be here. It goes without saying, I'll skip the formalities. I don't have the memory of Professor Krishnadeva Rao. Can you hear me? No, sir. A lapel mic. Okay, now I'll be too loud. Okay. So I'm properly wired and improperly audible. But that will bear with it for a while. I was saying I was delighted. I'm delighted. I've been to Nalsar before and distinguished faculty. I'm very glad to see many of you whom I met on this visit and some on previous visits. And I'm very happy to be here. And my visit owes primarily to Prema, who this is my first visit after COVID and long after the stroke I suffered from in 2013. This is my second life. And Prema has been very kind to hurtle the bones across the globe and change it to Hyderabad this time.
Mobile, and that's
Switch off.
so that I'll be fine.
Where is it? Switch it off, please. Thank you. You're very kind. So I occasionally know how to do it, but not always. So Prema decided to give me courage to come to my first experience in sitting in wheelchair. I highly recommend you, even if you're able body, because modern airports have to walk too much, too long. And it's better to sit in a wheelchair, which are principle opposed to, against the idea of wheelchair. So Prema, you owe this good or bad or mixed fortune to her initiative. I thank her for that. And to Amitabh for organizing this grueling program on both sides of doctoral scholars for last 100 years, it seems, but it's only fortnight, I think, but it's a long time. And I'm very pleased, therefore I know what you people are thinking of law in terms of future, next 15, 20 years. And that's very interesting. So I'm very happy. I counted when that, I beg your pardon, Mr. Chief Justice, Dr. Dhananjay Chandrachud. He was our student, so we used to call him by first name, Arjun Sikri and all these people at Delhi. At one time, there was no university law school except in Delhi University. By necessity, all the Delhi are our students, without exception. Now there are a lot more private law colleges, General and other places, but Delhi still retains its flavor. So I'm very glad to have come here and to be with you all. But when done, the Chief Justice Chandrachud was become, I beg your pardon, I should not refer to him public by his first name. When Chief Justice Chandrachud became the Chief Justice of India, I researched a bit and wrote about it. Task before Chief Justice Chandrachud. He has forgotten about those tasks and I have forgotten. That's a different matter. But my initial research was to find out how many prime ministers there were and how many chief justices there were. He was the 50th Chief Justice of India. He is. There are 15 prime ministers. That figure tells you its own story about asymmetrical relationship between prime ministers and chief justices. And these 15 prime ministers, many of them had a short spell of time. If you count people with 10 years or 15 years as prime minister, then in fact there were only 4 prime ministers. Similarly, I don't know whether Nalsar had how many vice chancellors? 4, I think. You are the 4th one, yes? And you had 25 years. You're doing better than the Supreme Court. And you're doing better. But this is the comparison I had in mind. And then I talked about irrelevant things before I come to basic structure. I did walk a long distance to reach you here. I didn't know you were in this side, and we came from the main entrance. And I suddenly remembered a great book by Nelson Mandela, A Long Walk to Freedom. It is biography. It's appropriate, and you must read this biography if you've not read it yet. It's a great book. And he did 27 years in Robben Island as a prisoner, or convict, and in solitary confinement. Again, he was against apartheid. He was considered a rebel, and therefore was imprisoned by the then government in South Africa and by British imperialism. The freedom is a hard-won thing. It takes a lot of effort to preserve it. It's a very nice book by Justice Jagan Mohan Reddy. I don't read, I've lost my copy. If anyone has a digital copy, you must send it to me, please. It was called, it's an American saying, we have a republic. The question is whether we can keep it. There was a series of lectures he gave, and I don't know where Jagan Mohan is, probably the other bird, but I've lost the book as well. So kindly send me a digital copy. I enlarge it and read it. So in a sense, freedom is hard one. And basic structure, the topic of today, is all about freedom. Freedom constitutes a limit to power. And basic structure doctrine is all about limits to power. What in there is the customary now to refer to Hindu thinkers and Hindu doers. Long ago, I worked on the concept of Maryada, long before people thought about Hinduization of the country. Because I'm a teacher, I'm a reader, and I do things which other people don't do. And concept of Maryada is a concept of limits. The notion of Raja Dharma, and Raja Dharma is limited by Praja Dharma, and both are limited by concept of Maryada. So Maryada is a sense of limits to power. It's a new, not a foreign idea. It's not an idea by Daisy Paisy, anything like that. It is a Hindu idea, if you want to go that far. It's ancient idea of just rulership, just kingship. We can translate in modern language. It's the idea of just use of power. It's an idea of just responsible sovereignty. That's a UN phrase for it. Sovereignty within the law, not outside the law, not unlimited sovereignty. That's the idea of this basic structure, basic idea. So I'm very glad you are celebrating. I'm addressing two anniversaries at the same time. The anniversary of Tulam, okay? Equipment downstairs, they're not bending down to me, I don't like it. I can't bend in return. My doctor has prohibited me to bend. But they were doing something to the machine below. And I was an onlooker. But I can't bless them, I thank you. So the idea of basic structure is complicated. It looks simple, it's limits to power, but then who sets this limits to power? That's the question. We waited for a long time for Parliament to set its limits to power. We waited a long time for executive to set limits to its power. All of administrative law, for example, a subject you learn and teach. You know, it's all about pathologies of power. It's all about excesses of power. Now, why in the name of everything that is holy? Can I sit back then? Can I be heard? It's all right? Okay. Yeah, okay. Take. I think there's some noise. That's why I want to be comfortable. And I also want to say with great respect to the organizers of the program, I don't like it to be a monologue. So kindly interrupt me whenever you feel like, or there will be some provision for question and answer session. Be careful of the wire. Yeah. Hidden wire. Okay. Oh, there it is. I've come to this room very often before, but now I find myself in a difficulty which I share with you. Okay. So, the concept of Maryada is very important. For who will set Maryada to power? And we waited a long time for this to happen. In 1973, the Supreme Court set limit to what? To amending power. This is where the basic of the doctrine comes in. And what did the Supreme Court do in Keshwanda Party? Now, the subject of my discussion is twofold. I want to discuss basic structure, but also want to discuss a second thing, which makes it difficult for me to handle all this in 1 hour, but I'll try. That is how not to read a case. Because judges perform enormous labors and we don't read them. Now, if law students and teachers don't read cases, who the hell would? Business management, commerce, faculty. They won't read cases. We are the only guys who can read cases and who must read cases well, properly. And we don't read them. Best of us don't read them. And this is a problem. I don't know how you handle pedagogy issues in your university, but I do hope you concentrate on this. So I've got two jobs at the same time to explain what is basic, to revisit the basic structure and to revisit how not to read a case. I'm nobody to tell you how to read a case, but I'm somebody to tell you how not to read it. So this will be two combined expositions simultaneously. So the first way of not reading a case is to skip the arguments that were not before judges. Judges in dialogue with lawyers, Keshwanda took 68 days to hear. 68 working days of the court were consumed. 13 judges said, imagine that's too time. It was reported from day to day at that time. You know, digital archives, you can do tuck, and find it today. You can do, tell be co-present with Keshwanda at the time. I know it's a late generation X or Y or P or Q, whatever. But you have got Twitter, you've got social media, you've got computers, and you can find out what happened in Keshwanda Party. I'm not going there. But the argument advanced by Niren Day was breathtaking. I don't know why Niren Day argued like that, but they had a brief from Mrs. Indira Gandhi or whatever cabinet, I don't know, the inside story. But he said by virtue of Article 368, I'm sorry, that 368 gives us the amendment of power, amending power for federal provisions that affect the states. It is 2/3 majority and the consent of half the states and so on. That you know 368. So when you follow the procedure, comes out the amendment which is per se valid. It doesn't need a stamp by the Supreme Court or anybody to say Parliament has acted unconstitutionally or not. It's simple. So he said, by virtue of 368, I can amend the Constitution under 368 to make India from a republican society to a monarchical or any other form. He said, I can make India a democratic republic, I can make it a theocratic republic. My power is unlimited. And he went on. He went on how 368 is the Constitution of India. 368 is one article out of hundreds of articles of the Constitution. But he said that is the article. And you must understand the constitutional history a little better than I have time for. Article 31, they got various amendments on right to property that Vice Chancellor Rao mentioned and other things. I won't go there. Essentially, therefore, the judges said, sorry, Mr. Dev, we can't go this far. We can't give the power. We have the power, plenty of powers, and we won't interfere to change the Constitution. Change in the Constitution is Article 368, amendment. Change in the Constitution. Mark the word in. Change of the Constitution is not allowed. You can't convert the democratic republic into a monarchy. You can't republic into a unitary state, federal into a unitary state, republic into anything else, other form of government. That you can't do. Now I say, what is wrong with it? Why there is so much ho-ha? The Supreme Court merely said ultimately that you can't amend under 358 the entire Constitution as you will. There are certain limits, implied limitations flowing from the text or provisions of the Constitution. This is the position accepted by the Union of India and by all major political parties. Nobody has sought a review of Keshwanath Bharati till today. They could have sought a review. Justice Beg and Justice Ray set up a bench to review Keshwanath Bharati, but there was no application by any law. There are no parties who sought a review. The Union of India did not seek a review. In the second judge's case, the Union of India, and that is right reference to my JSE illustration, the Union of India said collegium is a good system. In the third judge's case, President of India referred that please change it from 3 to 5. Collegium of 3 members, 3 to 5. We are not contesting collegium. It is what, Amrit Kal or something. 75 years, they're going over centenary of the Constitution. So many governments came. None of them passed a resolution or made an amendment like the one which is thought to be made in Israel, for example, that the court not come in. Courts have no power to hold a judgment of the parliament against it invalid. So they passed one bit of the amendment because then the violence happened, war happened. They passed the whole hog this time in October, but they did not do it because of Hamas. And the war with Hamas. But they passed one amendment already, which says Supreme Court shall not pronounce upon reasonableness of what we do, of law. Once we pass the law, the court is not to, that Aaron Barak did inaugurate in Israel the idea of judicial activism, and he said that we have the power to do it. We followed India. Barak is a great name in history. But this is all reversed in Israel. A beginning made, saying you cannot even question Even if the law is manifestly unreasonable, it is what we have done. And remedy lies with us, not with you. This is what they said. But here, no amendment of that kind has been passed. I'm not advocating it. But that opportunity to seek a review, they did not. They in fact conceded the validity of basic structure when they say 44th Amendment. Second Amendment, which is the Indira Gandhi Amendment, ruled, among other things, had a very nice provision that X number of judges would sit jointly to hear a matter, substantial question of law. That 2 judges bench, 3 judges bench. 44th Amendment reversed even that. You leave it to independence of judiciary. Nobody, no government in India has contested basic structure. They might take pot shots here and there, trigger controversies and so on. I'm not interested in the politics of it. I'm not a student. Despite Krishnadev Rao's generous reference to my Supreme Court in politics, a book you must sometimes read, even though it is dated. But that I'm not talking my book. Sorry, that's all right. But he read it, he would say it. No, I think that part. No bibliographical bravado. But I think Supreme Court judgment has been accepted by the Union of India because they have not filed a review, nor has there been amendment. No, now there was an Nalsar amendment. Soon after Keshavanda, Mr. Nalsar was MP, moved an amendment, and that amendment never saw the light of the day by the same regime which said I'm unlimited sovereign, I can appoint, change the constitution. So, where is the dispute, I say? Where is the judicial overreach? When you yourself find it convenient that judges examine the amendment. This is the conclusion I draw, because otherwise you would, if it really bothered you, you can legislate amendment. And the third schedule of the oath of the oath is about our oath. Judges take an oath to do what? To uphold the Constitution of India. Mrs. Gandhi, Indira Gandhi, by 42nd Amendment, introduced the word as by law established. It is there in the book that the Constitution at least takes. I wonder what law, how can law establish Constitution? Constitution is a higher law. That's what we are told. How can ordinary law establish Constitution? But this is what you take an oath. But you also take an oath. I don't know why judges take oath. I wondered why they take it. They even invite me to the oath taking. I said, how to go, because kind of mandamus. I don't know and go. But I don't think judges should swear such a blasted oath, such an oath. Because the Constitution is a higher law than the law. Because by Constitution you judge the validity of the law. So how? No doubt Parliament must pass an act to amend the Constitution. The act is a bill and law. So Constitution is a trivial thing established by the law, amendment. So they must be in mind proper exercise. But the amending power is now limited by 368. So oath is obsolete. You can't introduce by law established. It's a metaphor, your consideration for future when you study constitutional law and politics. Or I am sorry. So I'm not even done my first point. Some note. So I think the matter is who will decide final. Now I tell you, I don't know how close you are a deal of constitutional law and politics, but a simple question. How many amendments under Keshwana Bharti have been rendered invalid? And how many cases Keshwana Bharti was argued? 6. It was gradually expanded, Keshavanabhati, as normative progeny. I call them normative children of Keshavanabhati. The first was Keshavanabhati. The second major break came. Keshavanabhati said, we will only apply this basic structure doctrine to amendments. Bommai said, we'll extend the constitution, we'll extend the basic structure to power to declare precedence rules. It had nothing to do with constitutional amendment. Nagaraj said, the third case, whether it affect a paradigm shift or not, I don't know. The people looking very learned, they intimidate poor me. I said, it's a paradigm shift. In, sorry, you also used the word paradigm yesterday. I'm from Gujarat law. I studied my English literature in Gujarati. I speak very bad English. I but pronounced cage correctly in 6 standards. I got a prize. And to spell it correctly, at the level of English, we avoid English in Gujarat. So it's that kind of English that I'm familiar with. So I don't think, and most of these letters are more difficult with English. Now got it, Nat and Hita, and all this reform law, the wave of decolonization, so-called of law. What kind of decolonization it is when you preserve 98% of the old law, and yet its package is decolonizing the law. I'm not on the Sanhita, so I've written 6 or 4 articles on that, India Legal. You are welcome to read it on the net if you are interested. Recently, I've written my little Sanhita. I reply to the big one. In response to the big one. I've not exported my. Anyway, so it is. This is the major point I wish to make. What is India? You would say the democracy. Yeah. I think it is the other democracy. It is opinionocracy. Opinionocracy. Opinion, belief, and judgment. 3 things. 3 things are important to me. Opinion, O, B, J. Belief and judgment. Now, opinion and belief are necessary for democratic order. That the northern votes, and you are prime minister or chief minister, whatever you are. So we are a democracy because we are opinionocracy. Earlier, I used to say opinions are as cheap as onions. But now with this expression, onions are very expensive. I think export of onions has been prohibited. Time to time it is prohibited. So it is not even onion. I know it's cheap as anything. What else can I say? Opinion is as cheap as one. Nothing is cheap. I don't know. I don't know about the inflation business. But that is not my field. That's law and economics. To study this would know better. It's not my field. So I think it's a everybody is that true opinion, and a dance of opinions is the dance of democracy. That's all. And majority takes it all. That's democracy. Some people have proposed the word term electocracy for democracy. They first past the post, they get the elections, they rule, and then they claim absolute power to amend the constitution. That's a different thing. So belief, I'm puzzled. Today, 78% of American Republicans believe that the elections, last elections in US were stolen by Biden. That there was fraud, despite the fact that the state election commission is certified, the American Senate is certified by vote. It's a procedure there, certification of elections. That certificate, elections were free and fair. 78% of some of whom are American House of People or senators believe that elections were stolen by Biden. That's their opinion. It's not the law. It's not the judgment. So how do you distinguish? I distinguish, say, belief and opinion are subjective. You may believe in God, you may not believe in God. You may believe in heterosexuality or you may believe in right to sexual orientation. It's subjective. You may believe anything you like. And there is something called freedom of speech, no, in India. But it is interesting. It's a very interesting country, as I said to somebody the other day. It's a very interesting country. You have freedom to shout from the rooftops, freedom of speech and expression. But nobody is under duty to listen. So it's opinion. So public opinion is very important for democracy. But this is not judgment. And what we people do in law school and universities, particularly law schools are experienced, is to confuse or conflate opinions with learning, with judgment. I've often heard the NJSC case, judges appointed judges. No country does it. I've never heard anything more absurd than that. But it passes the wisdom of teachers who tell the students that our country is unique. Judges appointing judges. Collegium can't be transferred. I'm not Professor Rao will tell me, he will tell me, and everybody will tell me. Or any idea of university appointments. That you cannot be transparent in appointments. One post of professor, 150 apply, all qualified in the UGC rule. I had experience in that university, professor of technology. I invite 150 people, 11 days of my time. One person appointed, 149 will say arbitrary. You cannot make selection process accountable or transparent. I only do it procedurally. So judges appointing judges and executive appointing judges, the citizens will never know how judges are appointed. We will never know whether the government appoints or the chief justice appoints and the collegium appoints. We will never know on what basis. And now there's an argument in the Supreme Court going on the election funding cases. What is it? Bonds or some? Electoral bonds. Electoral bonds. Which is interesting, and you guys should look at it now it is on the television in your spare time. I hope you allow some spare time to watch television. Okay, oh my God. Now, with the highest authority, you can do that. So you can look at the audio-based view of Supreme Court process. It's been argued by no less than a solicitor of India that, and it will be argued by Attorney General of India also, Nakatamani, that people of India have no right to know who funds the political party. What transparency? The basis of democracy, and it's being argued that you have no right to know who funded the elected parties. And all political parties say this. Mr. Gandhi said this, Mr. Nalsar Rao said this, Mr. Manmohan Singh said that, Dr. Manmohan, everybody says this. It's nothing new. Can you believe it? Being argued that people have no right to know. And yet when judges are appointed, you want transparency. How is it? Here they can't be transparent. Here they have got 400 judges or 500 judges in the High Court. Everyone wants to come to the Supreme Court. 33 vacancies, 33 in all. Now, but no matter how transparent you are, where you select. So people have not read Justice Kerr's opinion, which is 500 pages long, in NJC case. Nobody I've met has read the case. Nobody in India. I challenge you. And yet the judges appoint judges, which passes as wisdom as what NJC decided. NJC did not decide that judges appointed judges. It said two things. As you know, I've done military, I think you all know it. It says that the law minister and two eminent persons, no criteria for eminent person. An eminent person can be anybody. So, law minister and two eminent persons can override the advice of the Chief Justice. You better improve your bill on collegium and make a better appointment system. You don't take away the limited primacy of the Chief Justice of India. That's the idea. You don't veto him on judicial appointment. Here the Chief Justice of India means collegium now. Secondly. Secondly, he said, government never sought a review of second judge's case. Never sought a review. They agreed in the third judge's case when the president referred, I mentioned that he said 3 to 5 you increase, but we are not opposed to collegium. They accepted it. Third thing I had, the Union of India is a continuing entity. Prime ministers and governments come and go. The state secretary, chief minister come and go, but they are permanent entities. The law secretary of Union of India filed an affidavit. All this is in case judgment, but nobody read it. What can I do? Please see judgment. For God's sake. He has said, out of 400 appointments we have made since independence, 396 were with the concurrence of the Chief Justice. Now you all say in your classroom, I dare say, that concurrence is not required, it's consultation. Concurrence is different. And this is judicial overreach. Complete baloney, bogus. Because this argument was made, it was heard, here over 500-page judgment in which he says the limited primacy was awarded to the Chief Justice of India in 394 out of 400 appointments since independence. It is there in the judgment. But we have not read either the second judge case, nor we read the NJC case. So we say consultation is different from concurrence, and that passes over learning, legal learning, political science learning, authoritative, and then you write down notes, and there are questions, and you answer it. Then I can't understand. What are the universities meant for? If not for judgment. Opinions, you can have any number of opinions. Go write it, I don't care. But that's the opinion. Judgment is, judging the judges is the hardest of all tasks. So what judges have before them, you don't have before them. You don't have the arguments, but we don't have the argument. We in India do not know two things. We look means the law people and people associated with law. We don't know two things that are important to know. How judges think. You know, the slightest clue of how they think. And we don't know how lawyers think. And yet we sit on the judgment of lawyers and judges, and that is considered scholarship. I shudder to think. And what are the intergenerational consequences of passing this bogus knowledge, fake knowledge, to your students? No teacher has consciously asked this question. Now, mind you, there are limits to reading cases. I've spent all my life, but I still read them. Bad habit, you say. But to judge what judges are doing the normative labor, you must read what they say. Otherwise, you judge by opinions and by belief. That's all right. They don't have to read. In forming an opinion, you don't have to read a single thing. This is your opinion. You don't have to study anything. In forming a belief and attitude and approach, you don't have to study anything. It is only when you form a judgment that you study it. But belief is not knowledge. Knowledge is produced out of judgment, whether in social sciences or in other sciences, human science. So, I wanted time for you to. I'm speaking, but you might have this is very undemocratic dialogue. This is not basic structured dialogue. There are no limits to what I can say. But if there are any comments sideways, frontal, any questions, what do we do? Do we leave some time for discussion later? 10 minutes, give me 10 minutes more and then you will have a discussion, yeah?
Yes.
Okay, then hurry. So I think I've made enough of my point of this business of Judge Ostraker also said in this NJSC case, they no harm with the corregium, but just make sure that the eminent person's qualifications are prescribed. Krishna Iyer, yes, Krishna Iyer, wrote to me, my current Krishna, that namesake. And he wrote to me in Surat. He said, you become vice chancellor of South Gujarat University. Congratulations. I said, Krishna writing to me. Obviously, there must be something else, and there was something else. Krishna could never speak without references and twist in the tail. So he said, sting in the tail. He said, but of course, but not so. Who said, and you know, eminent educationists, they said. And he said, but remember, not so. The more eminent you are, the more things you've done ashamed of. So by that criterion, we are all eminent persons. But the court was saying, here has a 20 pages, which you must read for general education. 25 pages. I don't know where you get it from. I don't know there was so much on this theme. On gratitude and loyalty. That once you are appointed to the Supreme Court and you know that somebody is in your favor, you, in Indian culture and other cultures, you feel duty bound to return that favor. And therefore independence is affected. And yes, done science. There is articles in American political science even on gratitude and loyalty and so on. It's gone on and on. We don't read this treasure. We die without knowing what the judges have said, and yet we are law teachers. I don't understand law students. Why do we do that? We call that, it is absolutely incredibly unjustifiable. Let me not go on to that. So therefore, now, keeping is not reading. NJSC case, it may surprise you. There are 2 judgments. 5 judges have written first word recusal judgment. And then followed same 5 judges give a second judgment. So they first NJSC opens with 5 judges' opinions on recusal. And then it proceeds to the second judgment on the commission. Now, that is the point that you don't read. It was the first judgment which made possible the second judgment. Why? Because they did not recuse themselves. And each one wrote an opinion. Chalameshwar goes so far, Chalameshwar goes so far as to say, we have a defense of necessity. Since everybody is a member of the potential, actual or potential member of collegium, there will come a point where there is no Supreme Court to opine on whether the legislature is valid. So Chalameshwar goes very far and says we can't recuse. Kerr says, Justice Kerr, sorry, beg your pardon, I just dropped justice between this discussion. It takes total time. Kerr says, I will want to know the list, constitutional list. List means the subject matter of dispute. If there's a professional list, then one can. Then Madan Local goes on their own trip and says, Madan is dear friend of all of our dear friends. But Madan says, you must give objective reasons when refused. Objective reasons are litigable because I can go to the other bench, civil result. So ultimately, say none of us will recuse. But nobody has read that. It is non-recusal by judges that constitutes the bench continues. And then they give the opinion. So please remember, Madan said, Lokoman is a concurring opinion of great magnitude. A very good opinion, in my opinion. That's a strange argument. The legislature represents the will of the people through the amendment. 20, up to 26, 18 or 19 have passed the NJSA bill. Refer to that overnight. So this was the case where Parliament felt that we had done our homework seriously, everybody has agreed. There was no opposition excluding one lone member in Parliament, that was Ram Jethmalani. And page after page, Madan Loko quotes Ram Jethmalani. Why did Ram Jethmalani dissent in the bill, NJSA bill? He said this is a road to repetition of emergency. Where Ms. Indira Gandhi called for committed judiciary. The alternative, ladies and gentlemen, to collegium is committed judiciary. The partisan judiciary. Our liberties and our rights are to be adjudicated, not by independent, robustly independent judges, but by politically participant people. And that's not what our Constitution says. So Balan Loko goes to town on election down Jethmalani dissent. You read, and you read it. Maybe it takes half a day of your time. And you read what they. So they've said rationale for collegium is not that it is the best system. But no system is best. But we don't appoint parties to litigation to elect their judges. Union of India is the biggest litigant in the country, followed by various states. State of Bombay versus so and so, state of Madras versus so, state of Andhra Pradesh versus so and so. Why? Why can't you behave properly? Until the court tells you to behave properly. Why there are years in the court? Ramita is teaching administrative law, sometimes writing or administrative law. Why administrative law? What does administrative law say? It says three things. Here, audio, partam, something. Here, both sides or something, all sides. It says, Nemo iudex sua causa, nobody shall be judged in one's own court. And it says something else for the third thing, it says something else. But lovely.
Reasoned decision.
Reasons. Give you reasons for this. Why can't they do? Why do we need administrative law? Why did they not internalize this in 1950? Why do we need administrative law? This big books are written. Why? Why can't you perform according to power, according to law? What's the problem? The problem is we adopt fly now, pay later rationality. We will dismiss this inconvenient SP today. He will be reinstated by the court, we know. But he will be suspended. He will be reinstated with back wages, we know. But the later government will pay the back wages. We are not paying it. It will be removed. It opens sesame for legal administration. Is controlled by the judges. Actually, he was very happy with it. Why can't the bureaucracy internalize the three rules of conduct, give reasons for your decision? Thank you very much. Here it is a sign. And don't judge a case in which you are involved. What? Why don't they do? Some people do the IAS courses, do IAS. Why can't you internalize this? Why do you need court to tell you this? Why administrative law? Extraneous reasons, all that. all these things will go if the bureaucracy followed basic postulates of administrative law. You would not have administrative law. You don't need the books and teaching and subjects like administrative law in the curriculum. That's why I call it, Dr. Ram, I call it pathology of power. It's fly now, pay later rationality. Which is the problem? And we don't get it. So anyway, finally, therefore, I now give you one point only. Then I'll write it all up for your students who could not come today, a colleague who could not come. Remind me, I do it in point form, not in articles, but something that you can discuss among yourself as to where I might have taken a wrong turn. And then tell me, please. The two point is the judges have a very difficult job. Please, ladies and gentlemen, please appreciate this. If you were a judge, how will you decide the case? So they write wrong judgments. They even give concurring opinions, which my friend and colleague, Professor Dr. Puneet Putaya of the Indian Law Institute, has whispered into my ears. There's Article 145 of the Constitution. I don't have it here, Constitution, but you look it up. You look up on the web. 145 provides for a majority opinion and a dissent. It does not provide for concurring joint opinion. It's very strange that Supreme Court judges write concurring opinion. It's unconstitutional. If you concur, you concur. Why do you have to write a separate opinion concurring with? Reducible load, बाबा हम भी पढ़ते हैं, हमको पढ़ना पड़ता है. आप perform Hindi, Hindustani, पढ़ना पड़ता है हमको. We have to study this thing. We also have a life to live. We also have our pleasures and so on. I mean, teachers have to do other things in life, not just teach and be with students. So why this unnecessary surplusage in judicial? Now, that's a very good point. It's actually prohibited. You can't write separate according to Putaya, Puneet Putaya. It's very good point, I think. That's escape my notice. But that is a separate concurrent opinion. How do we deal with it? It's very difficult. I take it from me, it's extremely difficult. Recently, the same-sex case I'm working on now. Chandrachud writes, Chief Justice Chandrachud writes an opinion in which he says, Ravindra Bhatt in his opinion says this, and Justice Ravindra Bhatt says this and this, but he's all wrong. He's all wrong. So he goes on saying where he's wrong, where he's wrong, where he's wrong. He doesn't know any constitution, doesn't know any law, doesn't know the precedent. I don't agree with my learned brother, he's learned, and he's brother, but I don't agree with. Fine, you can disagree. But in law, there's an animal called per incuriam. So if you have not come across it, you will come across it. It says if you are, you should come across it. It says a judge should not disregard, I think, am I right, precedent, or should not be ignorant of a statute which is relevant to the case. Roughly. Now, Chief Justice does not ever say that per incuriam. But de facto, he says it is per incuriam. This man does not know any constitution, precedent, law. And the Chief Justice of India is saying it. In written opinion. In same-sex marriage case, people of India expected a 5-judge bench to deliver a judgment. If you apply doctrine of per incuriam, only 4 have delivered the judgment. Bhakti is wholly Paranikuyam. So very difficult. So it's very hard sometimes. Sometimes reading judgments responsibly with studying them, after reading them, you have dark consequences. I had dark consequences. Justice Beg in Keshav Bharti, he had a heart attack, but he said of opinion. And he agreed, he said, I agree with my learned brother Matthew and Vedi. And I found that Matthew and Vedi did not agree inter se. The student of law in the article you refer to, Keshav Bharti, Quicksand, 1974, I just come to India. So, Arey Baba, how would I make sense of Justice Beg? Where do I apportion him, ratio-wise? So I said, one-third Justice Beg, one-third. I divided the opinion in one-third. The consequence, I printed it, 1974, as you see, it printed. Beg was very upset, Mirza Sahib was very upset. So after return from the court, I told Amita this. She haunted me like a spectre. Everything I went to the public speaking seminar or something. After seminar, I raised his finger. He said, Professor Bakshi, you done a wrong to me. My subject was somebody else. I said, sir, why have I done wrong? You should say me. You should be in the podium. Why should you sitting in the audience? He said, no. You denied me natural justice. You didn't share me before you divided me one-third, one-third, one-third. Now, scholar writes after a lot of study, points out that your judgment is not unsound, but it is apportioned. Then you count majority, mathematically. So sometimes you're faced with like the same-sex question. I'm not making it public, but my finding is Chief Justice Chandrachud is held that Bhatt does not know any law. That's clearly Pankirya. And without Kuyam, we have four judges, not five. Now, it is something that same-sex people may not want. It is something my friends in the movement do not want. It is what I do not want, perhaps. But when I study judgment, I'm helpless. So sometimes I'm consequences. I should take the consequences. I'm currently a very lonely person because of my work. Why I'm lonely? Because that man is quite crazy. He divides back into one-third, one-third, one-third. No, I don't. He is crazy, Baxi is crazy, he's getting very old. He now says there is no judgment in same-sex cases. But I'm applying what I've learned to a flow. My teachers told me very young, learned operas in Bombay in 64 before we were born. My apologies. But that's how the world is. So this is how the world is. Some crazy. So sometimes you incur this cost. And finally, I would not say any more. But I think one thing I must say, and you must watch Pierre's judgment very carefully. He says basic structure is a fragile bastion, not a robust foundation. He uses the word fragile bastion, which are not his, which are English judge writing on how judges should behave. The message that goes out, he should go out to a student, is that basic structure is not robust, it is frail. And the power at the highest seat and source, the Supreme Court of India, is the most vulnerable. It's a confession of vulnerability of judicial power. And therefore we exercise cautiously. Various ideas I wrote on my time on this. There are a number of problems, the plurality of opinions, such as doubted. So I call it indeterminacy problem. I call it the operational problem. They're very anxious whether a judgment would be affected, how will enforced or not, how directions will be taken. The legitimacy problem. whether other people will consider our judgment legitimate or not. There are all kinds of anxieties that judges have nobody to share with, excepting their research assistants. They said, I don't know. So the fragile bastion. It's not a robust structure. But here I end abruptly as I started. And leave whatever time there is to a discussion, to a comments, to a questions, to a pointing out where I've gone wrong. I must have gone wrong because I've spoken 45, 50 minutes. It's impossible not to go wrong.
Thank you. Basic structure as freedom. I think that is something that we'll take with us and think about for a while. But in the meantime, if there are any questions on anything that Mr. Bakshi has said, the floor is open for questions.
Good afternoon, sir.
Good afternoon.
My name is Arnav. I'm from the recently incorporated LLM IBL batch. And it indeed is a pleasure to have you here and soak into the lecture that you have delivered. So my question is based on the OBJ trichotomy that you just suggested, the opinion, belief, judgment trichotomy. Can we say that the Supreme Court failed in not recognizing Justice Subbarau's concern about the importance of fundamental rights that he raised in the Golaknath question?
Slowly.
So, can we say that the Supreme Court actually failed in not recognizing Justice Subba Rao's concern about the importance of fundamental rights in the Golaknath's case? Because he was spearheading the bench and he laid down his opinion that how come something that is so fundamental be made tool of legislator, be made a tool for the legislature to play with?
Yes, so Goraknath is undergone. Some people say about basic structure that it is a ordering of Goraknath is wrong. That Goraknath need preserve fundamental right for amending power. But there is discussion in the NJC case and elsewhere, where it says that basic structure is going beyond fundamental rights. Part 3. Subbarau's whole ideology as a judge, I've studied him. Subbarau was against statism, what he called statism. I didn't like state undertaking all economic activity, all educational activity, all. That is the concept in political science, you would have heard about it. The state is everywhere, society nowhere, kind of thing. Roughly speaking. So there's one argument is that if basic structure applies to entire constitution and applies beyond a constitution, precedence rule, or to reservation, Nagaraj's case. The courts have to determine the basic structure. What is the basic structure? There are two phrases used. Basic structure and essential feature. Very often I'm asked, how am I feeling today? Australians have a different accent. So they can't pronounce they die. They sounds like die. So did you come to hospital to die? And you are Indian, English, yes, certainly. And you suddenly run out of the hospital. That's not the point. So what is the relation between basic structure and essential features? Question Goraknath never. Now, that is a difficult question because not everything is basic structure. You can say A is not basic structure. A is also not essential feature. Therefore, Parliament can do anything it likes. The first question is, what the hell is essential feature? So I often ask, how are you, Professor Bakshi, how are you today? I say, oh, well, thank God to the Supreme Court. It tells me that my basic picture is okay. My essential basic structure is okay. But essential features are all upside down. Okay? This is my condition today, health-wise. Casual now. So basic structure means power to articulate essential feature. Otherwise, basic is useless. You go behind the idea of basic structure. What is that basic? Two phrases are used. You must be very careful. Thank you for asking this question. You have to go beyond Guruknath to do all this. Basic structure is the power to articulate essential features. That power is CJR, Baxi Baron, like oxymoron, I tell them. CJR constitutes judicial review. Independence of judiciary and power of judicial review are the basic structure. If you didn't have this power to say what are the essential features, basic structure is no good. So you must distinguish between basic structure and essential feature. Now, some essential features, there are three questions. One, how do I identify that something essential feature? Second, what is the relation between basic structure and essential feature? Third, is this essential feature violated? Fourth, if yes, does it reflect the basic structure? So you might have a essential feature being violated by law. Now this money is made, these arguments are making free to you. Making available. Teacher does this job with lawyers to charge high fees. Judges get very well paid. We are where we are. But I make it this largest available to you. If you can say X or Y is not an essential feature. There is one way to do it. Second, you can say Y is an essential feature. Therefore, it is related in a loose way to basic sense. But not all violations of essential features are violations of basic structure. Some violate basic structure, some do not. So, although essential feature is violative of violated by law, the law may still be valid constitutionally. Supreme Court has held that. Further development basic structure. So they have traced, in my opinion, the relation dynamic dialectic between basic structure and essential features. All this Goraknath did not do. Subharam no Subharam. This is, I think, one thing that you have to bear in mind. Violation of essential feature is not always a violation of basic structure. This may look like very odd to you, but that is. If you look Janeth's case in 2013, the economic reservation Marathas or some such thing on Brahmin-based reservation, you'd find Justice Ravinder Bhatt. And I asked Ravinder, how did you manage to be a minority, being a senior judge? It was a possibility of colleagues, but they did not. And that was aside. But I'm still reading Janeth. Now, basic structure is used by lawyers very confusingly as a technology of statutory construction. This is not the idea of basic structure, it's the idea of this constitutional interpretation, not statutory interpretation. There is a difference between statute and a constitution. That Amitabh will tell you, or your teachers will tell you. So, in a sense, if not every violation of basic essential feature is violation of basic structure, then the question arises, Why the name of Allah is the essential feature. But that's the difference between essential feature and basic structure. The difference is the power to articulate what is the essential feature. That power requires independence of judges, the rule of law, etc. This is autonomy, as K.R. put it. Once you articulated that is an essential feature, how can you violate it? But judges say, wait, Professor, wait. Not every violation of the essential feature is violation of basic structure. It should do something to independence of judiciary. Violation has to do something with independence of judiciary, then it is violation of basic structure. Power to articulate what is the essential feature. If it affects that power, then it is wrong. Then we'll hold it in debate. So it's a very often which the judges make law as they like. They don't make law as they like. It is very disciplined. Basic structure is not to be lightly, basic structure violation is not likely to be entertained. You have to make a strong argument that this goes the roots of judicial power to say what is the right thing to do. That is two words, basic structure. We do basic, the rate of surgery must go to the root of jurisdiction. So basic we know. So that's why they probably traveled well beyond Guruknath. If that was your question, I don't know.
So, my name is Utkarsh Bansal. I'm a LLM student here. My question is in reference to the concept you mentioned of Maryada and Prajadharm, which has a constant tussle.
Concept no?
Prajadharm and Maryada, which you mentioned earlier. Yeah. And in reference to also the reply you mentioned, was something like a women reservation on the Supreme Court bench, which kind of doesn't look like an essential feature of the Constitution, which kind of is a requirement of the as we move forward in progression of society. So kind of it mingles with, as I can see, with the Prajadhan to an extent. So how does it tussle with Maryada in totality, as in how does the independence versus the social obligation of the government moves in collate with the essential features or basic structure?
Yeah, very good question. I don't know. I don't know the answer to it. But I think because those who wrote of Maryada were not aware of Supreme Court and Article 15, and they didn't address this stupid things like we do. They were metaphysicians of Hindu metaphysics, nirvana and moksha and whatever different things. So they took Maryada in a material sense, yes. They did talk about that. Rajadharma is not possible without Prajadharma. Raja has certain duties towards Praja. And Praja has certain duties towards Raja. So they are interrelated concepts. They expect, even in administrative law, something called reasonable expectations. No? Something like that. So there are reasonable expectations in Dharma. Reasonable desires. Dharma, Artha, Kama, Moksha. They are four things. So Prajadharma and Radharma related to these four things. You know, the four things, Dharma, Artha, Kama and Moksha. Now we have taken a wrong turn when we say Manusmriti is the basic document. It is basic document for Dharma. But Vatsayana is for Kama. You can't apply the concept of Maryada to Kama Sutra. You can have Radharma and Pradharma and to Kama Sutra. It's a complete Dharma Shastra. So, Artha Shastra is the science of material interest. So, each has its own Maryada. Each discipline divides its own limits, it works with its own limits. Now, on the question of what should be the quantum of reservation, What is the sense of the question? What is being asked? Can you simplify it for an idiot like me? Very simple. Independent
To progress.
right? Slowly. Carry on.
Independence of the judiciary
Uh-huh.
vis-a-vis social progression of the communities we haven't given power to. Something like women on the Supreme Court benches, wherein the Supreme Court haven't done clearly a good job.
Oh, yeah. But that Maryada is exactly the concept of Maryada is limits on power. But limits on what? Power. There must be power in order to be limits, no? So there is Raja Dharma, but Raja has to rule. Parliament has to make laws. There is a presumption of constitutionality of legislation in our statutory interpretation. The judges will be very slow to reverse a parliamentary decision. They must always presume that legislature intended to remedy the situation constitutionally and not otherwise. That legislation is per se constitutional. And it's on the other side to show that it is not. So essentially, therefore, there has to be power in the first place in order that there be limits on that power. So Parliament, every Krishna party and all this think bank says one thing, all powers are constitutional. They are limited, given by the Constitution, they are limited by the Constitution. Including judicial power. It's not unlimited, it's not undisciplined, it is limited by, bounded. So every power is supreme within its own jurisdiction. Right? No other person can come into that. No other power can come into that. Legislative, executive, judicial. Right? And therefore Parliament has vast powers. Basic structure does not touch them. The basic structure proceeds on recognition of that. So, whether Parliament in this or that case is using its power wisely and well, is for progressivity or regressivity, is for each individual too. If it's a judgment, then you read some materials. If it's a belief opinion, you don't have to. Sitting in the armchair, you can formulate whatever you want to have to of the world. So, this is where I will stop. Yeah.
Okay, sir. My name is Yasir Pathan. So,
Yeah.
I'm from IBL batch LLM1. So, sir, I have one question. You being the scholar of constitution law and like you have researched entire life on basic structure and constitution. So, I have a very simple question. What do you think? Like, what are your findings looking after the society and looking after the current scenario? What should be the real basic structure which would be applicable in current society as a constitutional scholar?
What?
According to your, like, I need to know your own findings out of it, like your own opinion about it.
Things this work.
Good afternoon, sir. I'm Yami. I'm from LLM IBL section. So my question is that generally the basic structure of the constitution provides division of powers between judiciary and as well as the state. But these days, do you think that judiciary is taking law in its hand and making its own rules? For example, if we see Indaswani case or Vishaka guidelines, wherein judiciary would be giving much of the laws and regulations, even does like judiciary taking things in its own hand, is it affecting the basic structure of the constitution?
Thank you. Thank you.
First of all, good afternoon, sir. We are welcoming over here you. Thank you, Nalsar University, for giving us this opportunity. So, sir, my basic question is, in the middle of the lecture, you stated buy now, pay later is the problem. So, can you just throw some light over it so that I can understand why? Because according to me, buy now, pay later is the form for the development of a country. Means people can achieve things. People can have what they desire for in the meantime, and then they can pay later. But right now, can you just throw a little bit light on that? Thank you so much. Would you fly now?
Thank you.
Okay, sorry. I'm sorry.
Thank you.
Thank you.
One more.
Good afternoon, sir. Thank you, Nalsar University, for this opportunity. It's an honor and privilege to have you, sir, here. So my question is whether the basic structure was successful in protecting the original values of the Constitution in the present scenario.
Original?
Uh, whether the basic structure was successful in protecting the original values of the constitutional in the present scenario. Yes.
Okay.
Hi, sir. My name is Irshad. I'm a PhD scholar here. My question is regarding the constituent power. So when you keep the unamendability of basic structure, at the same time, we should look into where does the constituent power lies in. So in that case, the constituted power of the parliament and judiciary. On the other hand, the constituent power, like where do we actually locate the constituent power in case if the question of unamendability of basic structure arises? Yes. So in that case, if we can think about a constituent power where we can locate even the amendability of basic structure. So like, that's my question.
You pay, poor me. I take the last first. Professor Rose and I, of Vishal, has written a very good book called Unlawful Constitutional Amendments. And this book is published by Oxford University Press last year or year before last. And he collects not just India, Indian doctrine of basic structure has spread to a lot of African, Asian, South Asian nations. Plus European nations have their own versions of basic structure. So this notion has been used, is widespread in the, what is my friend, what's the name? No, it's not my friend, if I can't remember his name. Chris, you must know him, who wrote a book on juristocracy. Yeah, that's right. That chap wrote a book. So it's part of juristocracy. Democracy is juristocracy, epistemocracy of some kind. Epistocracy of some kind, jurisprudence. So this is a common culture of humanity, which area which I did not address. There is no attack on the power of parliament. Where does sovereignty lie? It lies nowhere. In West Bengal, there's a Burakur coal mining company, 1955 decision of the Supreme Court. They grappled with this problem. And Barakar Coal Company, they said there are two kinds of sovereignties. One is legal sovereignty, and other is political sovereignty. Political sovereignty belongs to the people. Legal sovereignty belongs to those institutions in which it is vested. Simple. So they said there is a dialectic between, not they said, but my reading of it, there is a dialogue between political and legal sovereignty in the matter of constituent power. But constituent power is the power to amend the constitution. And Nani Palkewala's argument in Keshavarnanda was precisely this. That blah, 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 when procedure is followed, this thing done, that thing is done, states are consulted, were consulted. The Section 4, Article 68 says, the Constitution. That's an amendment. The Constitution. What is it that says an amendment? If you repeal, it is not an amendment. That was the argument of Ramjesh Panay, the argument of several other colleagues. They stopped at each word. Ram was with me at the air flight from Delhi to Bombay. He said, Chup. Bolna nahi. Ram is not speaking. Voluble speaker. Chup. And it was Chup. He collected his bag. I said, Ram, please tell me what you're reading all this time in the plane. He said, I was reading Article 368 plus up clause 4. This is called reading. The Constitution still remains. What is that? The Constitution. Something must remain. That is the basic structure. It does not give you the power to, because what is the mandate? The Constitution. What remains? If you make it from monarchy to, from democracy to monarchy, from republic to monarchy, whatever. What remains? So, Article 68 is not a power to amend, make changes in the Constitution, but not take changes of the Constitution. Now, it is important to say, well, people have a constitutional power, but where is it in the Constitution of India? Which political party has introduced a bill on referendum of the Constitution? Amritkal, no? I'm not asking any political party to introduce it. It will run the test of basic structure. Now, 50 years later, it's too late. Constituent Assembly did not, idea of referendum did not appeal to them. They rejected it. Whereas Britain's referendum, many countries have referendum, Switzerland. We don't have. So the power lies in a wise co-governance of the nation by parliament and a judiciary. Co-governance in my concept is important. Not confrontation, but co-governance of the nation. And that's what basic research does. It says within certain outer parameters, you can do what you like. You can have central vista in parliament. You can demonetize. We totally see judgment on election bonds. We just see judgment Article 68. There is no problem. There is no unamendability. Parliament can do anything it likes within the Constitution. What is within the Constitution? That which does not offend the basic structure. So the old arrangement continues. Why worry about constitutional power? Accommodation among institutions of governance. That's the idea. That's the idea of co-governance. Wise accommodation, that institution of governance must not fight interstate. That's the idea. So that's my saying on that. My take on it, very brief, but there have been several valuable comments. Thank you for that. There was the comment of, I've written down, but I can't read it. Separation of powers. One comment was separation of powers. Now, in 1950, Ramjabaya was the state of Punjab for 55. The Supreme Court said, and Gopal Swarup Pathak in Vice President was the advocate for they nationalized certain textbooks. And the Punjab textbook Walas went to High Court. And he said, the judge said, the Supreme Court said, that our constitution does not know any idea of the word important. Strict separation of powers. Strict separation of powers. That's repeated consistently by the Supreme Court till today. It was repeated in education. But still, belief and opinion is separation of power. What can you do? I'm not gunning at you, I'm saying generally. The belief is in one part, what separation? Your own court has said so. But you have a strong, her belief in separation of power, she is entitled to believe. But the Constitution does not contemplate a strict separation of power. Now, what the hell is a strict separation of power? Is the question. It means that we don't follow the English or American doctrine of separation of powers. We follow our own. So essentially, it's a unity of state power, if you want to go that far. It's not separation. It's working cooperation for good or bad of the country. So don't be careful about separation of powers, because I think our constitution does not seem to like it. Our constitution says to achieve goals of part preamble, values of preamble and goals of part 4A, the Supreme Court and the High Courts and the executive and the state legislature and the parliament, sorry, there is no D before parliament, sorry, parliament should work together to achieve part 4 duties which are paramount. That's what it says. That's what is transformative about our constitution. It says work in cooperation. We work in disharmony, in conflict. Conflict is not bad. It's good sometimes. But we've forgotten part 4. Now, what the paper is written, who talks about socialist pattern of society or discrimination? And all this in part 3 and part 4. Nobody bothers. So that's the question of related to one comment that was made of apply now, pay later rationality. Is another name for democracy? Or is it another name for constitution? Or constitutionalism? Whatever is the name for democracy is not necessarily the name for constitutionalism. You must make a difference between systems of governance and CJR, Constitutional Judicial Review. If you don't make it, nothing but I will not fall, but I think one must make a distinction between buy now, pay later rationality is we have the power now. You do X and Y. We are not bound by any duties. The great German theorist, sociologist, Nicholas Luhmann, in the 6th page of his book on sociology of theory, says this, and we don't study legislation, we don't necessarily Bentham or somebody, you don't try to read legislation. Legislation nobody reads. So we have a lacuna here. We've studied legisprudence seriously, not jurisprudence, legisprudence. Then I remember Amita did study at the Indian Law Institute on statutory orders and regulations and how the Committee on Subordinate Legislative Function. Everybody said, why are you doing this? But see the point. And we published a book in the Indian Law Institute, several books, that this is the regulation that they produce. Everyone must know about it. Or that we can't know about it because it's not secret, but it's not available. Whatever. So I think you take a try now pay later rationality may well be a democratic virtue even. Virtue of system of governance. I don't know enough. So who pays later? And who flies now is the question for me. I was told by one of the PhD colleagues whom I met the other day, he's working on airport and security, and he said, and he's a turnkey, he was in previous life, before he became researcher, he was a turnkey project manager to ready-made airports to give to government. And he told him before the thing about disability became famous, Hyderabad airport he had designed, which had no barriers. And it went through, his architects went through. It's very nice thesis that's coming on your way across you. Rajesh, I think his name. So there is policy space in which you can do good for in your domain expertise. And it may be accepted by governments and the state also. But there's something called regulatory space where there's jostling between private advice and public wisdom, or whatever it is, collective. What they call it, trust in democracy or something, that kind of thing. So it's a matter of doing your sum side. But it is not, the point I was making is not the same as constitutional reason. That's what constitutionalism is. And finally, I'm sorry, I'm not, this question of design, which is partly associated with fly now, pay later. That politics is based on desire. Desire for what? Power. And more power. Endless power. Power to do what you like. Power to do good, power to do bad. Power to do in between good and bad. That desire for power. There is a desire for justice, which is why we go to courts and think about courts, that court dispense justice. The desire to do justice. So karma is the basis of governance desire. Why do you want to? आराम से बैठो जिंदगी जियो, why do the prime minister, chief minister? बैठे आराम से, अपने बच्चे हैं, बाल बच्चे हैं, बड़े सोचते हैं they're good people. We enjoy our life. I can worry about politics. But governance desires are based on accumulation of power to do what you like. Similarly, desire, why should you become a judge? We want to dispense justice. You have something in you that tells you must return to society what you know and what you have get got from it. Some things, I don't know what makes a judge, citizen a judge. I don't know. But certain citizens prefer to become judges when they could have been lawyers and earn more money. So we construct a desire is of it. Scholar desire is to gain knowledge. If scholar must remain ignorant, the contradiction interrupt. But we have scholars who don't want to question knowledge. Very interesting. I discovered Nalsar, we have scholars who don't want to pursue knowledge because they think it is a disabling discipline. Knowledge is a crippling thing. You must It does not let you do things your own way. And there are peer groups with their supervisors and people with PhD, and then there are committees, and there are vice chancellors, the registrars, and all kinds of people who watch over you, their colleagues. Whereas you want to be free of all these people, you have to do say what you like and what you want to do. I think it's very important. I think I've learned from this interaction. Thank you. Because people want to pursue knowledge in their own way. And the universities set a lot of obstacles in pursuing in the name of discipline, faculty, and interdisciplinary research. They want to do their own things, but they're not enough to do that. And yet, they've lo and behold enrolled into your doctorate program, which is very good. They're in your PhD program, but they don't want the jing bang of all this regulation. They want to do free research. And we, the old days, that don't allow them to do it because we think they must do it, there must be the animal on the hypothesis, operationalization, literature survey. I don't want to do literature survey. As somebody, you say committee specialized in literature survey, so we say literature survey. Why should I survey literature when write a thesis? You take me on what I say and look at my footnote. But let me cite whomever I like. We don't allow it because we're a university and knowledge is certain systematic order. That may be right, that may be one view, but there are other views. So that's, I think desire is very important. Desire is the central category, not just for power, not just for democracy, not for justice. And somebody that said to me, and I think there's a very nice book by Roberto Ungar on passions, Passion. Passion. How do passion, not desire, passions work, subconscious desires work through your discipline. They're very important. So I think we are in 23, no? 23 November. 20. So we're nearing the first quarter, ending now, first quarter of the 21st century. It took us 70 years to become independent, freedom from British yoke. Now we are marching to Amrit Kal or whatever that is, 100 years of this constitution. Why can't we do some new things? Why are we bound by old things? That's the question the young people are asking, and I think it's a very important question. So let them produce their own knowledges. The conflict is of our own, so what? Out of that conflict, something will emerge. But universities are not places for free research. They're places for disciplined research. So where do I go? To be a doctor in law. Where do I go? I have to come from university or the other. And that university would not let me do what I like. In the name of discipline, scholarship, knowledge, whatever it is. Maybe. Maybe the idea of aesthetic was a good idea. Renounce every institution and be your own person. Maybe it's much better to be that. But then where will Professor Rao go? I mean, we need students. So please enroll in on the 25th jubilee of this great institution. I say come to Nalsar. It's a great center of learning. Because they have to allow scope for free initiative and yet to contain it in some way which is not overly intrusive. This is very difficult because you know the difference between a vice chancellor and a governor? There was Home Secretary who became Vice Chancellor of Bihar. It's a story I learned. Positive. I won't name him. He was the former Junior Home Secretary. And he was very fond of novels. So he read novels all the time in retirement as governor. And some vice chancellors came to me. I'm not a vice chancellor then. Said, we want to take a delegation to because he had passed an ordinance in Bihar, which in Hindi said, Vice Chancellor shall be Prasad Paryant. Doctrine of pleasure. Vice Chancellor would be at the Prasad Paryant appointment to the governor. Governor can register any time, 5-year term, no term, Prasad, the doctrine of pleasure. He implemented this in Bihar. And our job was to persuade him to withdraw this ordinance. I said, I went there, was reading. So ultimately, he was reading novel. He said, no, I can't do this, I can't do this, I can't do this. I'm a governor, my powers are limited. But I said, you have done all this yourself. He says, I know a little bit of doctrine of pleasure. I was former, home minister. I take you to pleasure. That's why we're in the home ministry. You can do what you like. So, but the difference is, then I got angry. I really do. And I said, Mr. So-and-so, you know the difference between academic and this I translated vice chancellor. And any other person, governor, I said, governor, a governor is in charge of forces, like old people. And lived his life, retired. He no more, he has been the former Home Secretary, in charge of elderly people. Where the Vice Chancellor is in charge of, is held captive by young minds. This is yesterday evening, somebody came to me, a student from you, and I'm very proud of your student. Only 17 years young, Sadiq, and presented me a book, which he wrote when he was 15 years young, called Dear Bird. And I was surprised. And this man is your student. He already published a book. I have to read it. I don't say anything about the book. But so you have astonishing variety of people making demands, having expectations of you. So vice chancellors and colleagues in National University have a tougher job than ordinary universities, other university law schools. Because you come with great expectations and put the burden on your shoulders. Your teachers and senior people's shoulders. And they have to meet them. And as years go by, we grow older. And they grow younger. Mubarak on 25th anniversary. I'm very happy to be with you. And Mubarak on the Bharati on his 50th anniversary. Thank you very much. Oh, thank you.
It's an honor for Nalsar University of Law to host. Is it audible now? Yeah. So it's an honor for Nalsar University of Law to host the most respected legal scholar to come on our 25th Silver Jubilee celebrations to deliver this lecture. And we thank you, sir. We are very, very thankful to you. And I request our Vice Chancellor to honor him with a
Give me a shot, better give it to Prem.
Yes, sir.
Hold on, Prema. You
Yeah, yes, okay.
Thank you, sir. Thank you very much. And I thank all the participants, students, and the faculty for coming over. Thank you.